Mr. Samuel, any reason that Mr. McIver and I should have our conversation?
Well, we think it ought to be done outside the presence of the prosecution, not necessarily in public. On the record, no.
Okay, good. All right, that last one, you're going to get some pushback on.
Yeah.
Why outside the presence of the prosecution?
Because of Fifth and Sixth Amendment.
Okay.
We could just have them decline to answer any of your questions. That's not going to do any good, which we wouldn't do if we were doing it outside the presence of the prosecution. I don't think they have the right to hear his testimony, which you want to hear.
I don't know that it's testimony. It's not under oath. I'm not going to swear him in. And he could refuse to answer. But, Mr. Rutgers, you have I've never encountered this before.
I haven't either.
Okay.
Been asked to leave the party. And I don't know, is there a case or is there some precedent?
Well, I guess there may well be, and it might be cited, although it might have been when this, to me, novel approach was suggested. I know in a capital case in which the state is seeking the death penalty, not this case, every time that a judge has a hearing, the defendant ought to be there, and at that conclusion of that hearing, the state leaves, and there's a whole dialogue that formerly was somewhat substantive, and now under, I guess, the state of practice, the defendant, politely or not, says, I'm not going to answer your questions, and that's fine. And maybe we're analogizing this to that. Why should the public be excluded from this exchange? Is there a fifth or sixth penumbral privacy right?
I mean, we're going to do it outside the presence of the DA, but the public can be there, and that should be obvious. If we're entitled to do it outside the presence of the DA, it ought to be outside the presence of the public also. I'm concerned about the press, and I'm concerned about, I don't know exactly what you're going to ask. I know the general topics, but I've never had this meeting before. I don't know what's going to end up happening to that. There are all kinds of things. We know juries don't always 100% comply with what they're supposed to do, but this would be particularly risky. And I just don't see the need. There's just absolutely no need.
What if we defer this discussion until you've called all your other witnesses, so that the answer would be if Mr. McIver chooses not to testify, when the jury comes back in, you rest. And it doesn't matter what's reported in the media. The jurors will have experienced the fact.
Oh, I know that.
Okay. And if he chooses to testify, then guess what? You'll say our next witness is...
Obviously, that's my concern is not the jury learning that he's not going to testify. My concern is the extent to which you go into questioning him and ask him about his knowledge of the law and his knowledge of...
Let me preview for you what I'm going to ask, and maybe that'll change your analysis. And you should listen, Mr. McIver, because they're questions for you in the end, not for Mr. Samuel. I'm going to ask you if you understand that you have an absolute right to testify, and that if you wish to testify, no one can prevent you from doing so. I'm going to ask you if you understand that you have a corollary absolute right not to testify, that if you choose not to take a stand, that's a decision for you to make. Though you're free to consult with others in reaching your conclusion. I will explain, I ask you if you understand that if you choose to testify, you will be required to answer non-objectionable questions from both sides. You don't just get to answer the questions from your lawyers, but you would be subject to fair cross-examination. I will ask you if you understand that if you choose not to testify, then I will instruct the jury that that decision cannot be used against you in any way, and that they will be instructed not to draw any hurtful or harmful inferences from the fact that you didn't testify. Because, of course, the defense has no burden of proof. And I'm going to ask you if you want to testify or not. And if I believe that your answer is based on a full understanding of your rights as guaranteed under the federal and state constitution, then I will respect your answer. I suspect you will understand what it is I have to ask, but I ultimately will say that I find, if I do, that you have decided not to testify with a full understanding of your rights and the consequence of the decision. That's about it. I don't promise word for word of that, but I do promise we won't get into other areas. In light of that, does that change your request?
No.
Okay. I am not going to grant your request. In light of that, do you request that I defer this conversation until you let me know that you have otherwise exhausted your witness list? It's okay. You can speak too. You're part of the team.
Well, I don't know whether there's any requirement that you conduct that inquiry. I don't think there is. There's no uniform superior court rule or other inquiry. What I have done in the past is that I have, during a break, engaged the court reporter to take down a colloquy between myself and my client, and had that made a sealed part of the record. The inquiry is very much the same as your inquiry. Therefore, it's not a public proceeding, but it is preserved in an official capacity, which I think is what we all think is appropriate. And I had always done that on my own, and I can suggest a procedure that.
Okay. Anything from the state on this?
No, I'll
Okay. I think it's appropriate for the court to conduct the colloquy. I think it's important for the court on the record, that doesn't necessarily mean in public, but on the record to make a finding that the defendant made his decision to testify or not testify with a full, complete understanding of his rights. I don't think we are on the firmest of grounds if we rely on a recorded colloquy between counsel and client. I am less certain about whether it, for any reason, needs to be a non-public event, but I'm not sufficiently persuaded by what either defense attorney has said to believe that it should be a non-public event. And so, having said no to the attorneys do it with Mr. McIver on the record outside of everyone's presence but the court reporter, and no to we exclude the public and the state from the colloquy. I'll ask one more time because I didn't understand your answer, but you were still thinking about other options.
be good now.
Now, okay, great. Mr. McIver, are you able to hear me? Sure. Okay. Do you understand that you have a right to testify, and that if you wish to testify, no one can prevent you from doing so? Okay. Do you understand that in that same vein, no one can compel you to testify, meaning you also have an absolute right not to testify? Do you understand that?
I do.
You understand that in the end, while you are free to consult with your lawyers, with an investigator, with family members, etc., it's ultimately your right and thus your decision whether you testify or not. Do you understand that?
I do.
Okay. Do you understand that if you elect to testify, if you choose to testify, then you will be subject to examination, not just from your lawyer, but from one of the prosecutors as well?
I do.
Do you understand that if you choose not to testify, that I will instruct the jury that they are not to use that decision against you in any way during their deliberations? The defense says no burden in this trial or in any criminal trial and the jury ought not to draw any harmful or hurtful inference from the fact that you choose not to testify. You understand that I will tell the jury words to that effect if you choose not to testify. I understand. Understanding the things you've told me you understand, Mr. McIver, do you choose to testify in your trial? No. Okay. Well, I find that Mr. McIver has made his decision not to testify with the full understanding of his rights, that he's had time to consider this decision, and that he has made the decision knowingly and voluntarily and intelligently. Thank you, Mr. McIver. Mr. Rucker, you had said that you were ready to do your re-examination, if that's the right word, of Mr. Gardner based on juror questions. Are you ready to go forward with that?
Yes, sir.
And Mr. Harvey, just in case during the break, did you come up with anything else you had wanted to ask in connection with those juror questions?
I'm glad you added the comment in connection with it. You were looking at me and starting.
I just dug a hole for myself.
Yes, yes. No, thank you.
Okay, all right. Anything from the defense before we bring the jury in? Okay. Mr. Rucker, anything from the state? No. All right, let's bring the jurors in, please. Mr. Rucker, you've been very patient.
Yes, sir. All jurors are present and accounted for, Judge.
Thank you, Deputy Murphy. You all may be seated. So jurors, I'm curious. We've been together now for a few days. Are you finding a certain rhythm at lunch? Friday is Moe's and Tuesday is Subway, or Monday through Friday is that little cafeteria there and the vending machine? Is there any kind of... Okay. All right. Well, I know there aren't a whole lot of options around here, but it's not a food desert. There are some dining options nearby.
Breakfast is great.
Breakfast is great.
Breakfast.
Meaning no, today's breakfast was great. Yes, so I heard. Good. And thank you for thanking your source of breakfast. We still have Mr. Gardner on the stand. When we had to break for lunch, Mr. Harvey had finished up his follow-up questions that were predicated on juror inquiries, and Mr. Rucker had indicated he had a few, and it's his, or more, and it's his time to pose those follow-up questions to Mr. Gardner.
Thank you, Judge. Good afternoon.
Good afternoon.
Good afternoon, ladies and gentlemen, and counsel, and Mr. Hyde. I do just have just a very few questions to follow up on the jurors' questions. And if I could get Mr. Rahmani to help me perhaps set up an easel real quick, I'll try and get to those. Mr. Gardner. I want to show you a couple of photographs. They are marked. First one is marked the State's Exhibit 281A. And if you need to come step down and look at it from the front to get a really good view of it. Can you see where you are?
Yeah, but once you ask your question, if you don't mind, I'll step down.
Sure. I wanted to have you take a look at this photograph and tell the jurors if, based on the analysis you did with respect to trajectory, if the placement of the hands that we see in the photograph here would be consistent or inconsistent with your analysis.
Inconsistent. The hands are in this, between the legs, and the trajectory's going off to the right side.
Okay. And so that's inconsistent, correct?
Yes, sir.
Okay. photograph. It's marked as State's Exhibit 285A. Could you take a look at this photograph? And it's the same question.
Yes,
Placement of the hands, consistent or inconsistent to the analysis that you did?
That one's tough. The perspective is all wired. It looks like the hands are a little too far to the left. The right hand is approximately where one might expect. But once again, for that photograph, the perspective, that's not a very good photograph to be judging it by.
Okay.
Generally, yes, maybe on that right hand.
Okay. I think that's all my questions.
All right.
Yes, sir.
Mr. Gardner, thank you so much. You are free to go.
Thanks, sir.
Don't let him go. Okay.
I can't go.
Go quickly. Defense. Next witness. Next witness. Okay.
No, the defense rests at this time.
Okay. Ladies and gentlemen, you've had this happen before when the state rested, but that is one of those junctures, or we've heard pivot points, when the parties and I need to have a conversation. And so this is going to seem a little choppy to you, but it's very normal as cases go along, because you just got comfortable and you're going to go back into the jury room. But I need to talk with the parties and then figure out what it is we're doing next. So please bear with us, and we'll get you out here as soon as we've got a plan. Don't talk about the case. Do not start your deliberations. Deliberations occur after closings and after I give you the final charge. Here's the law that you must apply to the facts as you find them to be. I will get you back out here soon. Just view this as sort of a post-lunch break. Coming soon after lunch. See you soon.
All rise for the jurors. Please be seated.
Mr. Samuel, are there motions or anything from the defense that you would like me to consider at this point?
We would review our motion for directed verdict acquittal on counts 1 through 5. With regard to 1 through 4, we maintain the same argument that we raised previously. We believe the evidence introduced during our case in chief reinforces the absence of the type of certainty needed in order to sustain a verdict on any one of the first 4 counts. With regard to count 5, we filed an additional brief earlier this morning. We let the DA know about it yesterday. I think that we draft changed a little bit over the weekend. We believe that count 5 we ought to, even though we introduced no evidence relating specifically to count 5, we believe that the arguments in our brief respectfully contradict some of the rationale that you used to sustain count 5. In particular, you want me to argue?
I think now's the time, so please.
Well, as with the last time we dealt with this, I filed a brief which set forth my arguments.
Right, well, when you say argue, let's address it now. I've read your brief, and I think I follow it. I am more interested in working through attempt versus not attempt, but I don't want to preclude you from reiterating that you did in here why you think none of that ought to be considered, because there ought to be a directed verdict as to count 5.
Right.
Assuming that doesn't happen.
Right, I think, I actually got a transcript of your ruling on count 5 from a couple days ago. My understanding of the way you saw that count 5 survived was not that simply saying to Danny Joe Carter, I don't trust these people, tell them you weren't here, or pretend you weren't here, or if asked, tell them you whatever the line was. If you view that as sufficient evidence to support a 161093B conviction because it was an attempt to mislead, that it was an effort to mislead, but it fell short because she wasn't misled, she didn't go to the police, or failed to go to the police, and that it really required more, but that's why it's an attempt, and because 1643 allows an argument of attempt anytime there's a complete defense, that's why we get to go forward on either the lesser included or the attempt type of 161093B prosecution. Studying it after you've made that ruling led me to do a little bit of research on, is there really an attempt for every single crime? And the answer is no. That there are several crimes, and I note 2 in my brief.
Solicitation, assault.
Or 2 examples where the courts, the appellate courts, have held there's no such thing as an attempt because the crime itself is completed before you ever get to the point at which you abort the process, which is true in most cases of attempt. You attempt to commit a burglary, you go to the property, you knock the door down, but then you flee. You hear the sirens coming. Well, that's an attempted burglary. You haven't completed it yet. You break into a car, you hear the sirens, you run away. That's an attempted theft. You haven't stolen the car because you hear the sirens and you leave before the crime is complete. Same with rape, same with so many different crimes. But what the court said is when it comes to a crime like solicitation, once the utterance is made, it's done. The crime's complete. You can back away and, whatever. The key is you can't focus on, as I call it, the person, the solicitee, the person who's being solicited. Whether the person being solicited is a cop, the famous undercover FBI agent who does all the murder for hire cases, or someone who had no intention of ever committing a murder, or someone who just changed their mind and didn't do it, you're still guilty of solicitation. It's not an attempted solicitation. You made the solicitation. Crime is over. If you didn't solicit the person, then there's no crime at all. There's no such thing as attempted solicitation. The courts have followed the exact same logic when it comes to assault. If you assault someone, the assault itself is an attempt. It's an attempted battery. Archaic thought there, but it's an attempted battery, and therefore you can't have an attempted attempt. Which is why the court, I think Patterson was the case that first articulated that you don't have such a crime. It is our view that if you look at the statute here, it's the exact same thing. I can imagine, frankly, a case where you do have attempting to mislead, but it's so weird that it's hardly worth mentioning. For example,
You could practice your voicemail a few times, but you don't. Here's the script of my voicemail.
Exactly.
Danny Joe, you better not do this anymore because it's going to hurt, etc.
Or you send an email to the wrong address, right? You send an email to Danny Joe and by mistake it goes to Bruce Harvey. So I guess one could argue that you've attempted to mislead Danny Joe in that situation. It's just you bungled it so it didn't get done. But that's not what we're dealing with here. We're dealing with someone who made a very specific, according to the evidence, not conceding anything obviously, but in the light most favorable to the prosecution, at most what happened was the following words were spoken to Danny Joe, period, end of discussion. Either those words were spoken or they weren't spoken. If they weren't spoken, there's no question that we win. If they were spoken, the question was, is that an attempt to mislead? And if so, is that a crime to attempt to mislead? And our argument is it's not. The crime is engaging in misleading conduct. Either it was misleading conduct or it's not misleading conduct. There's no There's no middle ground there. There was no abandonment of the project. There was no impossibility of the project, like if you're dealing with an undercover agent.
Sure.
You think you're, attempting rape, but it turns out that this person that you've assaulted is a man, right? That's the famous.
I think I follow that now. I mean, I think in this setting, if the facts were, and they aren't, that Mr. McIver told Mr. Maples, and Mr. Maples turned state evidence, hey, I'm going to go talk to Danny Jo and mislead her by saying it's okay to tell the police. Arguably, there's an attempted, but that's not the facts. The facts are he engaged in the conduct that the state has charged and has characterized as misleading conduct.
Right.
And I think that's our proper focus here. What Mr. McIver asked Ms. Carter to do, I think very clearly fits the rest of the statute. Withhold something from the police in connection with his investigation.
Correct.
And so we are very tightly on what was it he said, and is that alone enough to get it to the jury? And I'm inclined to agree with you that to call that an attempt, to me intuitively that made sense because you were convincing and saying, it didn't work. She said, I'm not going to do it. And so in some respects then it was attempted and it failed, but that was me stepping back from and not paying close enough attention to the language of the statute. And the focus is, did the accused engage in what the state is alleging to be misleading conduct? And he did. Well, the evidence is he said these words.
He said those words.
And so I don't think attempt is I will not charge this as an attempt.
Okay, so we've gotten there.
Yes.
Now the question is, and again, I wish I had your exactly what you said when you granted the directed verdict on 67 and not 5. It was our understanding, I'm going to share this anyway, it's wrong, that in essence you were finding that 5 survived not just based on the words, but because it was an effort, it was an attempt to mislead her. And because we believe that's what motivated your decision or prompted your decision, and now that we recognize that either it was or it wasn't, there's no half pregnant, that you have to reconsider 5 and decide whether telling someone to lie when everybody in the conversation, the two of them, knew it was a lie, whether that is misleading. And the fact that he's a lawyer, which I think you mentioned at one point, we think is completely inconsequential. The fact that he's older is completely inconsequential. That may make it look like coercion, but that's a different clause in the indictment.
I appreciate that. And I did say some things that if misconstrued could lead one to say, wait a minute, you're treating this like somehow he exercised undue influence over her.
Right.
And I think one ought not to ignore that, but I appreciate that's not an element of the crime. Let me try to encapsulate what I was saying before, and more importantly, it's what I'm saying now, and then you can push back on it as you see fit. In essence, I think the state could argue that Mr. McIver communicated to Ms. Carter, it's okay to lie to the police. That was his misleading conduct towards her. And she concluded it is not okay to lie to the police. But I think that there is sufficient evidence, viewed in the light most favorably for the state, to enable the state first to argue that the experienced attorney, someone older and wiser, someone knowledgeable in the ways of the world, who had Steve Maples on auto dial, to say to someone in this situation, it's okay for you to lie to the police, was Mr. McIver engaging in conduct that was misleading to Danny Jo Carter to get her to withhold. We're not arguing about the second half of it. We're focused on that. I don't know how convincing that is, but I could see a rational juror saying that was misleading to her. I appreciate your point. No, he's just saying you should lie. But it's not just saying that. And I think the state is entitled to argue that. And I think that it wouldn't be irrational for jurors to conclude that that was, in fact, Mr. McIver engaging in misleading conduct. Not threatening, not I'll get you if you don't, etc. Those factors may have been there, she may have felt that way, but that's not what's charged here.
I think the only thing I would respond to, first of all, I agree with you. If that's what he said, he would fit the pattern. In fact, the one Georgia case, the school superintendent, the school principal, who tells the student,
You don't need to be there.
you don't need to go to court, ignore the summons. Right? It's a nice parallel you draw, but the facts aren't there. I don't understand. There's nothing in her statement that said that he said to her, it's okay to lie. If he had said it's okay to lie, and implicit in that was, and I'm a lawyer, I'm telling you, believe me, lying to the police is kosher, there's nothing wrong with that, I wouldn't be standing here right now. I'd say, we got to defend count 5. But he didn't say that. You're inferring that somehow that message was conveyed to Danny Joe that it's okay to lie to the police.
So why should the state not be able to argue that that was part of the message? He certainly didn't say, I know you shouldn't do this, and it's a bad idea, it's wrong, and I really counsel against it. But you have this option. He didn't say that either.
I guess under that theory, you could also say, why can't the state argue that he also meant go out and shoot a policeman? Go out and, pretend you were in Anchorage. I mean, there's all kinds of things you could infer if you want to add facts. Why can't the state argue that?
Because he didn't say that. He said, you should tell them, I don't have the exact words, but
He told her to lie.
okay. Right.
There's nothing in the message, lie, that's any different than the King case, where one defendant said to the other, say it was my brother.
Well,
Were they allowed to infer in that case, it's okay to lie to the grand jury? It's okay to lie to the federal district court jury because, I don't know why. I mean, it doesn't even make sense to say that, but yet they're allowed to argue something that didn't happen, as if the state could just add an implication that he had. And even putting aside her inference, because that's not really relevant, what is it about what he said that suggests the further implication, and it's okay to do that? I don't understand how the state is entitled to make that kind of, added step to what was said.
okay. I hear you. Mr. Abate, you had been the spokesperson, but you're welcome to toss that potato to someone else. I don't see anyone leaping to your assistance.
I would submit on the brief of the state, this filed in response to Mr. Samuel's his brief. And just to respond to some of the things that Mr. Samuel...
You filed something in response to there's no such thing as an attempt?
No, the first one.
Okay.
Because it sounds like the court has already made your decision about the intent. So, and I don't believe that brief focused on the original issue, which was to have...
It did, but it didn't create new... It was a recycling because there was a prayer. One is not an attempt, but by the way, these things we said before, it should be directed toward attempt. Okay.
And the state would just submit on the same, rationale and analysis that we took as to count 5 in our response brief to the defense counsel's first brief, and I would bring to the court's attention just some of the circumstances that sounds like Mr. Samuel left out, but it was the court implied or brought to Mr. Samuel's attention was the entire context in which the statement was made and why it was made. And even when Danny Joe Carter, in response to what Mr. McIver said, which is something along the lines, and this is a verbatim, say you weren't in the car, you're here, you came here as a family friend, and she says, well, I can't lie, she says, but I'm on camera, and he says, they don't know that, or something like that, something along the lines of, or I apologize. She says, I can't do that, and they know I'm here, or something like that, and Mr. McIver says, well, they don't know that. So I think the context was he is further trying to get her to actually do what he asked, which was mislead the police when she was to make a statement.
Okay. It's not mislead the police, it's him misleading her. And I appreciate that this is close. I think the jury hasn't heard just one version of what that exchange was, but several. And I am finding from all of that it's a question that ought to go to the jury. But I appreciate how we are bumping up against a line of cases that says, here we don't have co-defendants. But I don't know that that's so significant. But the examples are usually co-defendant A saying co-defendant B, let's lie. And I'm not putting a lot of weight on that, but we are bumping up against a line of cases that say, accused encouraging other person, witness, to lie to police, to judge, to prosecutor, that's not the misleading.
Can I add one thing?
You may.
I apologize to the state since I'm raising something now that I didn't raise before. If you look at the indictment, it doesn't say he misled her by telling her it's okay to lie. It doesn't say that. If that's the core of the case, if that's what you're saying is the absolute actus reus of this crime, it's not there. It's not what they alleged. The only thing that's alleged is she was urged not to tell law enforcement. But you got it in front of you?
Yeah, I do. Now I'm confused because it says he told her to lie.
That's right. But he didn't say what you said was the essence of the crime, which is it's okay to lie. Well, that's the key, Judge. That's what made the school principal had been, of course, that crime didn't succeed anyway. That's what made the school principal guilty was what the misrepresentation was. You don't have to go to the hearing. That was the essence of the crime. Here, you're saying the essence of the crime was it's okay to lie. That's not what's charged. He's not charged with misleading her by telling her it's okay to lie. He's charged with misleading her by telling her to lie. And that is not a crime. Not this crime. It's not this. Yeah. That's the morning perjury. That's, there's all kinds of crimes.
Right.
But it ain't this.
You walk through the litany of other options that are not in the indictment.
Right.
All right, I'll need to think about that one.
And to add to my arguments, an amendment to the indictment, there's all kinds of ways I'd like to articulate the problem. It's an amendment if you change what the actual crime is. It's a variance if you're changing the facts to be something other than what's in the indictment. And the indictment itself doesn't even allege a crime, as you've now defined it. It doesn't allege a crime at all. So we would file a oral general demur, if you will, that this doesn't allege a crime.
I haven't defined it, but I will be guided as I was with count 7, in part by the language of the indictment. I have been focusing on statute to make sure we were fitting there, but it also, of course, we are cabined in no small part by the way in which the offense was charged, and I need to think through that. So I'm deferring ruling on your renewed motion as to count 5. I'm denying your motion as to counts 1 through 4. I think there is sufficient evidence in the record, even now that we've heard the defense presentation, to get counts 1 through 4 to the jury, and the directed verdict is denied counts 1 through 4. It is still granted as to count 6 and 7. That hasn't changed, and I will take under advisement count 5 with the proviso that regardless of how I come down on it, it's not going to be, oh, maybe it was an attempt. Attempt is off the table now for count 5. Anything else from the defense?
We argued before trial that leaving count 6 in there, despite the complete absence of evidence, was an effort by the state to put in the Black Lives Matter issue as counts, which otherwise would have been entirely irrelevant. And we argued to you ought to sever that. Even if somehow they could someday make out a case there with some other statute, take it out of this trial because it injects race into this case. And we could all poo-poo that and say it has nothing to do with race. But listen to Mr. Crane. All you got to do is mention Black Lives Matter and the world went ballistic, right? Everybody viewed it as being a racially charged comment. We can say, well, we're much better than the rest of the world, and nobody, we shouldn't pay attention to it. But that's what happened when people hear that. And it was for that reason that before trial we asked you to sever that count and give the state 2 bites at the apple. They could try this case first and then try that count later to see if they could get a conviction there. They decided not to do it. They wanted to keep it in this trial so they could make the Black Lives Matter argument to the jury. They put it in the opening statements. They asked numerous witnesses completely pointlessly to nurses and doctors and maybe the police, I don't remember. Did he mention Black Lives Matter? Did he mention Black Lives Matter like it was the most important element of the defense? Exactly what we contended was going to happen. And then sure enough, the court grants a directed verdict. And now, kind of mysteriously, the state says we still get to argue Black Lives Matter. I'm sure they're not going to spend 2 hours arguing it, but they're going to get it back in there. As if it has something to do with this case, and it doesn't. So we think you ought to have granted so. And as we told you at the time, if you don't, and it gets dismissed as it will, we're going to be asking for a mistrial because of allowing them to, in our view of their indictment section, whoever did it, to bootstrap in this racial argument where it doesn't belong, has tainted this jury with inadmissible evidence. All the times that everything about Crane, everything about the different witnesses were asked, what did he say? Just like in cases where there's many federal cases where, evidence came in on a count that never should have been brought, count dismissed, mistrial granted. Sometimes as hearsay comes in, sometimes on a dismissed count, sometimes 404B comes in based on a dismissed count, and then the court says, you got to start over again because none of that evidence would have come in. How the indictment been sanitized to begin with. So we're asking for a mistrial.
Okay. Who's going to address the motion for mistrial? Mr. Rucker. Yeah.
I guess the first thing I want to say, Judge, is that
Let me pause for 1 second. I want to hear from you.
Okay.
It's only 2:35.
Right.
Do you have rebuttal witnesses available for the afternoon? Should some part of your team be starting to make that happen?
we're trying to, and it was just because we, in previous conversations, I know yesterday Mr. Samuel kind of said, well, I think we'll be done by noon, but I saw the no sign from Mr. Harvey, so we've been trying to work together to kind of make the trial flow smoothly, but in light of what they presented, during their case, it has altered kind of the number of rebuttal witnesses we were called. And so there only
means more or fewer?
Fewer. And so the couple that we would call, one is out of state and not available today. It's going to be our sleep expert, Dr. Pressman. And the second...
I have Borneman listed.
I'm sorry. It's Dr. Pressman, correct? Remember, we substituted.
Borneman was the one you couldn't sort things out.
We couldn't sort things out.
The guy from Minnesota.
Correct.
Okay. So Pressman.
Yes.
Okay.
And secondarily, we were going to recall Mr. Driscoll for a very limited purpose, just to respond to some things that came out in the defense case. But Mr. Driscoll, we tried to reach him today. We didn't give him notice to be here today. He had been available, yesterday and the day before, and he is at least an hour and a half away, is what he indicates. And so the third witness that we are contemplating calling, I'll just share with the court, would be Sheriff Howard Seals to respond to, Ms. Anderson's testimony regarding dinner at the Seals home that evening, in which I expect Sheriff Seals would give us some information about what it is he told the defendant regarding Ms. Anderson's presence there at the ranch with him.
That's 3. That's it?
And that's going to be it for us.
Okay. Is Dr. Pressman a full press counter expert or just touching upon the...
We're going to touch upon.
Okay.
Clarify a couple of contentions made by the defense expert.
Okay. But it sounds like none of those 3 can be here this afternoon.
Right.
Okay. Again, I do want to hear from you about mistrial, but we've got jurors sitting here. Sounds like we could have a charge conference this afternoon after giving everyone a little bit of a break. and cover whatever else we need to talk about jury view as well, if that's going to happen. What is your forecast as to how long it would take to present those 3 witnesses? Mr. Rucker, I understand there'll be cross-examination, but you guys have gotten to know each other and you're pacing in the trial. Dr. Rye did not take a whole day, and this is responding to as opposed to creating from whole cloth a new perspective on the science of sleep analysis.
Right. I would expect we could get through those 3 witnesses by the morning session.
Okay. All right.
I'd be surprised if we did.
Or at least in the day.
Yes.
Okay. So if we bring the jury back in a minute, I'll hear from this defense in a second, to say, you gotta go home now, you're gonna come back Monday for, is there a SIR rebuttal expected?
Expected, not at this moment. The only one that I would like to wait and see what he's going to say is Mr. Driscoll, because I'm not sure what Mr. Driscoll would rebut that we put up.
Okay. All right, well, maybe there can be some conversating about that in advance. One, so you're not surprised, but 2, you'd be in a better position to say,
Yes.
Actually, everyone gets to meet Mr. Culver after all, or someone else, Ted, Mr. Ted. Okay. Again, I'm sure you'd be happy to come back. So I can tell the jury they're going home now. There will be a brief rebuttal case Monday, and maybe one other thing. But then they come back Tuesday morning for closings, because Monday, in my mind, is sufficiently variable that we could end up with the first half of the state's closing and then your closing and we end. And
Not good.
I agree.
Yeah.
So that's what I forecast as the schedule, is they're back Monday morning for the last bit of evidence. And if there is SIR rebuttal, it would have to be on Monday. I appreciate that puts you in a pickle, but Monday is when we wrap stuff up, absent a really, really impressive, convincing, misleading story. Tuesday then would be closings and charge, and the case belongs to the jury. Does that sound like a reasonable roadmap?
Yes, sir.
If there is going to be a jury view, and we'll talk about that after the jury goes home, you can logistically make that happen Monday as well. Okay. Yes? Yes. Okay. Great. Then my suggestion is we freeze the discussion about a mistrial, not to tip my hand, but then get the jury in here, tell them to go home with these scheduling updates so they can plan accordingly. And then we'll turn back to motion for mistrial. Anything else from the defense? Anything else from the state? We'll talk about jury view, and we can have a charge conference, probably with a break before we do the charge conference. Does that work for the state?
That sounds good, Judge.
Defense? Great, so thumbs up. Bring the jury in, please.
I'll do as the president and county court judge.
Thank you, Deputy Burton. The rest of you can be seated, please. My friends, it might as well have been Friday the 14th or Friday the 12th, because I don't have bad juju to share with you right now. Here is what it looks like the next few days of our together time are going to look like. You're going to go home in about 5 minutes, and I am going to spend time with the attorneys working through some legal issues. We're going to have what's called a charge conference, where we discuss what ought to be in the charge that I give you when you receive the charge, the law that you apply to the facts as you find them to be. So you get to go home a little early today, on a beautiful Friday, start your weekend early. You'll be back here Monday morning at 9 a.m. The state is going to present a brief rebuttal case, because they have the burden of proof. They have the right to put on rebuttal witnesses. You may even recognize one or more of the rebuttal witnesses. But the state's very reasonable. I have some confidence in this. I hope I'm not being misled. That the state's rebuttal will conclude on Monday course, the defense can cross-examine the witnesses. It's not just the state asking questions. And at that point, we will very, very likely be done with all the evidence. Closing arguments in this case, as I suspect you can appreciate, are going to be fairly sweeping because they have to encompass the 9 million days we've been together. And so both sides are allocated by law a fair amount of time to address you in these closing arguments and the attorney's efforts to persuade you to decide the case in their favor. And if we were to start closing arguments Monday afternoon, we'd get about halfway through. And that is disjointed. It could be kind of unfair if one side got to present it all, and for all night you're just absorbing what one side said, and then you come in the next day. So ideally, you put the closings all in one day. And they'll fit all in one day because we'll start Tuesday morning with the closing arguments. They do have time limits to them. It's just they can be long because this is a complicated case. Closing arguments will be done by early afternoon, if not before lunch. I'll give you the charge. That is much shorter than the closing arguments. You'll begin your deliberations. So you'll begin your deliberations, barring some unforeseen Friday the 13th strikes on Monday or Tuesday, you'll begin your deliberations sometime Tuesday afternoon. And you'll be given as much time as you need for your deliberations. You don't need to decide on Tuesday what ought to happen with this case, or Wednesday or Thursday. You become the masters of the clock once deliberations begin. But importantly, they have not yet begun, even though the defense has now rested. So when I excuse you in a few minutes, it would be inappropriate and really just too bad after all the hard work you put in if you suddenly start talking with people about the case or start doing the online research that you haven't done and instead then posing good questions that the witnesses can answer. So even though you have now heard the state's case in chief and a presentation from the defense, we're not done yet, and it's not time to begin your deliberations. Enjoy a 2.5 day, a little less, weekend. Meet you back Monday morning at 9 a.m. for the state's brief rebuttal. And if there's any other evidence that's going to be presented, I've made it pretty clear to both sides. That's happening Monday, because Tuesday morning you'll hear those closing arguments, those summations, my brief charge, and then you'll begin your deliberations. Any logistical questions from any? Okay. As always, enjoy your time away. No outside research. Don't talk about the case. We'll see you here Monday, 9 a.m. The usual smiles on your faces.
All rise for the jury. Please be seated.
Mr. Rucker, come back to the podium. We need to conclude the discussion of the defense motion for mistrial in light of the directed verdict as to count 6, which concerned Mr. McIver and Mr. Crane's interactions.
Right. I'm going to ask the court to deny the defense motion for mistrial and to allow the state to argue during the closing argument the actual words that came out of Mr. McIver's mouth as he related them to Bill Crane. They are relevant. It's competent evidence, and the probative nature of it outweighs any prejudicial effect. And in my conversations with Mr. Samuel, I've kind of previewed for him that is not the state's intention to inject race into the case. I don't believe it's a necessary factor for me in order to sustain my theory and my burden of proof. But the truth of the matter is that when he made that statement to Bill Crane, he was trying to express a justification for having a loaded handgun riding down Piedmont Avenue that caused the death of his wife. Now, when Bill Crane reported that, what Mr. McIver said was, hey, I think that's a pretty good story. I think that might fly. Because you see, the story that I needed a gun to protect myself against a group of homeless people really was unreasonable. And that's been the testimony from a couple of folks, not only Bill Crane, but as well as Jeff Dickerson. When he got on the case, one of the first things he said was, hey, tell me about this Black Lives Matter. The defendant denied that he made the statement. And Jeff said, well, hey, you know, because it's kind of crazy that you would need a gun because of some homeless folks, because you've been living in Atlanta for 40 years. So, you know, the fact that it backfired on him and the press took it to another level should not absolve Mr. McIver of the consequence of making a statement in an attempt to mislead. Now, his credibility is going to be an issue. And what the state has shown time and time again is that he is lying. He is lying. Not only about why he had the gun, but about what happened once he got the gun. And that is the focus of the argument. The argument is not that, hey, you know, Black Lives Matter means that he doesn't like black people. Because actually the evidence has been that, listen, there are all kinds of folks that are a part of some of those protests. And with respect to this case in particular, Judge, this is what you know, we actually have a juror who has participated in a protest. And I will only identify the juror to draw your attention to it by saying the juror is Caucasian. So the argument is not about race. I understand that the court's order is that, you know, you prohibited the state from injecting race in the case, and you didn't even have to do that, but we followed the order because we didn't intend to do it in the first place. Despite the fact that there are perhaps inferences that could be drawn from some things that the court has excluded, but we have not argued any of those things. The reason why I would argue, Judge, that he has now tried to deny that he made the statement, and the reason why he has gone to such lengths to have Bill Crane lie about it is because he has got to create a reasonable explanation for why he has this gun. And when Bill Crane says, hey, you know, this thing is really going viral, he's getting calls from the conservative partners at Fisher & Phillips. It's only then that he says, you know what, maybe my attempts to lie about that is kind of backfiring on me. And I just don't think that the court ought to allow him to benefit, Judge, from that. You know what? I would be making the same argument. Suppose he had said, you know, there was a KKK rally underneath the underpass on Edgewood. I was in fear. You know, at those rallies, sometimes there's violence. That's why I had my gun. Well, I'm not focusing on the race of the people that are part of KKK. What I'm going to be focusing on is whether or not there was actually a KKK rally underneath the underpass on Edgewood such that a reasonable person would be justified in riding around in the backseat of a car with a loaded gun. And the facts of this case is just quite simply there was no Black Lives Matter protest going on Edgewood underneath the underpass such that he would have reasonably felt any fear such that he could have asked for the gun. And if there's no reasonable justification for him to ask for the gun, then I can argue perhaps there is another reason why he asked for the gun. And that's exactly what I intend to do.
Okay. Well, I appreciate the partial preview of the closing argument.
Totally.
I'm going to deny the motion. I continue to understand the defense's concern about some of the emotion and volatility that surrounds Mr. McIver's decision to share what he shared with Mr. Crane, and then Mr. Crane's relation of communication of that version of events to the media. I'm not doubting that at that time, that aspect of the story seemed to take on a life of its own, and maybe people lost focus of the fact that there's a tragedy and someone's life had been taken. But I find that count 6 or not, that whole line of testimony remains relevant because it is yet another version of how Mr. McIver relayed to someone about what happened during the car ride from Longhorn to ultimately Emory University Hospital. And those stories have varied, and variances in those stories are, I think, fair for the state to focus on. I appreciate Mr. Rucker's profession that the state's position isn't that this is all about race. You can't help but make reference to Black Lives Matter about race. It does that, and I appreciate that it has that collateral effect. But I don't find that the state's effort throughout all this has been to make it a race issue. They've certainly brought it up because it's not a convenient fact, part of the evidence for Mr. McIver, but it's admissible in the same way that I found the way in which Mr. McIver purportedly addressed Dr. Sellers' colleague. And Mr. Sanders said, well, just leave out that one last word. But if Dr. Sellers' recollection was, those were all the words that Mr. McIver said, and they were pertinent because it was part of that set of evidence relating to how Mr. McIver is processing the immediate aftermath of his wife's death, grieving, not grieving, how is he grieving, how is he treating other people. It comes in, and it is certainly prejudicial to Mr. McIver. But the test isn't, is this fact prejudicial to the defense? Much of what the state has sought to admit is prejudicial to the defense. I don't think that it rises to the level of prompting a 403 exclusion, partly in the way it was presented and partly in the way in which the state has been using it, and I hope will continue to use it. It may come to pass during closing arguments that we need to revisit this calculus, but at this point, as I said, count 6 or no count 6, I think this evidence would have come in, and it's relevant to the defendant's credibility, his various explanations as to what happened, and his recitations of what happened. I will deny the motion for a mistrial. Anything else from the defense at this time? Meaning you just rested it, so I'm not sure if you have a roster of motions you typically make.
Nothing else.
Okay. Anything on the state?
Will the court give us some direction on the jury view?
That's next on my list. I figure we'll talk about the jury view, then give you guys a however many minute break you want just to reorient to charge conference, and then we'll have the charge conference.
Okay.
So jury view. I continue to believe that a jury view is appropriate. It would be an evidentiary jury view. To Mr. Harvey's point, there's a scene view and an evidentiary view, and other than the court requiring the defendant to be present absent his waiver at an evidentiary view, I don't know there's much more of a distinction between the two, but this will be the jury looking at evidence in the case. I don't think the vehicle has been tendered as an exhibit, but we can work through those logistics. I think what we need to work through are where it would be, how it would work, and in conjunction with all that, dowel, no dowel, how that would play out. Are the jurors simply looking at the vehicle from afar? Are they sitting in the rear passenger seat? Can they close the door, not close the door? Can they touch anything, not touch anything? Those are things we need to work out in advance so the juror doesn't say, well, hey, can I get in the car? And then we're all looking at each other and trying to sort that out. So I'm going to start with the proponent of the jury view, the state, and I'm going to ask you to please outline for me and the defense and the record how you envision the jury view working. time, place, manner.
So I've heard the court's agenda for next week. And initially, the only thought I had was, timing-wise, would it be more appropriate to do the jury view before we got to the state's rebuttal, since they really are disconnected and they just heard from Mr. Gardner? It would be relatively fresh. But since we got the weekend anyway, I don't know that it really matters that much. And so I would propose to the court that timing-wise, we would do it at the close of the state's rebuttal case. If that comes at or near the lunch break, I think that provides an adequate opportunity for setup during the lunch break. I propose that the actual viewing itself be conducted down right below where we are. We've already coordinated with the Sheriff's Department to make the space available on what I have referred to with the court previously as not the judge's side, but on the Sheriff's Department side of that underground garage, which is secured. I would propose to put the vehicle in a space or at a place that would allow jurors to walk around the vehicle freely and look at it from the outside. I believe that that space is adequate enough to position the judge, the court reporter, the defendant's attorneys, and the state in such a way that we are not obstructive of the movement of the jurors around the outside of the vehicle. I would propose that in addition to this, one of the things that out of an abundance of caution that we would do is that the entire exercise would be videotaped, and the videotape would just be made a part of the record as the actual evidence of anything, which I'm not anticipating anything, but should something arise, somebody says something or does something, or that it would be captured for perhaps another reviewing party to look at. I believe that the court could authorize, particularly in light now of what we've heard from the defense expert, the jurors the opportunity to actually touch the vehicle. I don't say that we suggest to them that they should do it, but I think that we should communicate to them that that is an option that is available if they wish to do it. And by touch the vehicle, I mean open the doors, I mean be able to look on the inside of the vehicle to assess the dimensions that have been brought out by Mr. Gardner with respect to the constraints. We actually had a juror question that asked about the dowel, and they would like to see that. And I'm open to how that is coordinated, whether or not the dowel is in there originally, or if the dowel should be placed in there at some point, once they look at it without it. I'm just open to that discussion, but I do think as part of this experience that the dial should be inserted to show the actual trajectory, and that if jurors so choose that they be allowed to actually sit in the back seat and make some common sense determinations for themselves. I don't know that there should be a time limit imposed on the jury view. I think that we can keep it within reason, but I don't think that we should say anything to them about, hey, you've only got 15 minutes or stuff like that. I think they ought to be free to really take advantage of the opportunity. I know there's been some questions, actually several questions from jurors about the navigation system. And I know there's been testimony about the navigation system. I don't know if there'll be any request to turn the vehicle on such that they can determine whether or not the navigation system is operable. But I do think you should flag it and put it on your list of possibilities. I do know we have the ability to turn the vehicle on such that you could make, you could just hit the buttons and determine whether or not the navigation system works. And I think that should be an option if for those jurors who so choose to do it. Beyond that, Judge, I don't think I have anything else. I would just need to know, I guess, before we go home today, what the court's pleasure is, just so I can help coordinate with the appropriate parties and getting the vehicle here and set up and so forth.
Sure, I'll let you know that.
Okay.
We'll talk a little bit more here from the state. One question for you.
Yes.
You provide or at least coordinate with the defense if I agree that it should be video recorded, this process. The state is in a position to supply. I think it said one of the investigators would be able to record it.
That's correct.
Okay. Second question, in terms of timing, if it is going to happen, if it's the first thing in the morning, we know when it's going to happen.
Right.
If it is at the end, after your rebuttal witnesses have testified, that's more of a variable. And I'm neutral as to between the two, unless one of them might mean the jurors have to sit around for 45 minutes because the vehicle's not here yet or things aren't in position. And so I'm wondering, if you know that setup time is 2 minutes, then I'll let you guys decide if there's an agreement as to when it should happen, if it's going to happen.
And that was my thought, which is why I said it originally, because if I know if it's going to happen, then this weekend I can say, hey, have the vehicle brought over first thing in the morning, let's get the salary report cleared out, let's get the sheriff's department on board, and then we know, okay, 9 o'clock, this is what we're doing. However, I do believe that I also would have the ability to coordinate this such that I could say, prospectively, if it's going to happen, we're going to do it at the lunch break, sometime around 12:15, 12:30. I want the vehicle brought over here at 11 o'clock. I want it set up by noon. I want folks to be in place by 12:15. And
maybe someone on your team, investigative staff, could reach out to the sheriff's folks now while we're talking about it.
they came by during your break when you were off the bench.
Okay. I want to be sensitive to the sheriff's needs. And I know in the early morning, you cannot have folks milling around on the sheriff's side of things.
Right.
And so if we were to do the 9 a.m. option, I just want to know that the sheriff would say, that's fine. By that point, it's okay for you all to be milling around down low.
Okay.
Because if the answer is you couldn't do it anyway, it's not an option.
Right.
So maybe we could find that out pretty soon. 10 is the earliest we could do it? Okay, so then we won't do it at 9 a.m.
Right. Okay.
But if you all conclude that a good time to do it is, and it's a fixed time, well, I think we just need to have it around the lunch break.
Yes, sir.
Okay. Mr. Harvey, and needn't be just you, but you had addressed it earlier. Thoughts about jury view overall, yes, no, and if yes, your thoughts about some of these variables?
Well, I think we're clearly on a we're going to do it track. So I'm assuming that you're going to do it, or you're going to allow it, and that's fine. Let's work from that.
Okay.
That starting point. I'm not going to make another or any impassioned plea not to do it at this particular point because I do think it's important. My concern is the semi-logistics of it all. I know the down, not down question is a large question. I know that the jurors were very interested, and everybody is interested in maintaining the integrity of where the seats are and how everything was set up. And I think that it's going to take some time, I would hope, that Mr. Gardner and whoever it is that's designated by the state can get together and make sure that the scene is appropriate. And I think in good faith, everybody will be able to do that. I have no hesitation in saying that. But I don't know when that's going to occur. So I mean, we've got to build in some time for our folks and their folks to get everything set up. One. Two, the videotaping and the general lighting conditions, I think, is another logistical question we're going to have to deal with. Sometimes video cameras or even like television cameras, those with high resolution, have lights attached to them, and it makes things brighter and glarier, and it's a different condition than what could be expected of this scene at the time the incident occurred. I don't want to where the jurors can't see, but then again, I don't want it so bright as to be glary and you can see everything.
My thought on the videography is if there's any issue to it, we shouldn't do it. We have a court reporter present, and we can make a record when we return to the courtroom about any irregularity that occurred. And both sides will go, no, juror 17 never got in the car. No, juror 17 did and spilled her coffee all over the back seat. I'm not opposed to it, but I share your concerns. If it makes a juror nervous about getting in there or behaving.
And then they're going to be videotaped. You're going to have to seal that, and then somebody's going to have to. So I have problems with the videotape aspect of it.
Okay.
I don't know. I have been told, I cannot verify this one way or the other, but that the back seat has been changed, has been cut, or there is some. Okay. Yeah, the back of the front seat. The front of the front seat. So I don't know how that might impact.
This is the cut that the expert who didn't make the cut?
Right.
Okay.
Looked at the plastic mechanism.
Yeah.
I don't know how that changes the dowel aspect of it. So thank you.
It needs to be explored.
Right. And I'm just like Mr. Rucker, I'm flagging some of the problems that I may have. I want to make sure that we have the ability to make sure everything is coordinated with regard to the seat positions and everything. And then I want to make sure with regard to the dowel, I'm concerned about the lighting. Other than that, as long as Mr. Samuel can be in the back seat.
As opposed to Mr. Knox?
Yes, exactly. So, that's all. And I think, I'm confident that I can coordinate with Mr. Rucker this weekend, and we can get that. Logistical ability to get that coordinated, and we can get that done.
Great. So here are my thoughts. I think it's going to happen, and I need to give the jurors some explicit instructions. They will be able to walk around the vehicle. They'll be able to get into the vehicle. They're not going to be able to operate it, so the keys won't be in it. They can't turn it on. Frankly, I'm wondering if we ought to have the battery disengaged so no one inadvertently. Okay, good. All the testimony has been you can't move the back seat absent a bomb, but the front passenger seat could move, and I don't want it moving if it is put in a place that is mutually agreeable. It ought to be fixed in that way. So the car won't be turned on, but I'll explain to the jurors that should they choose to, they can touch the car, they can get in the car, they can't touch if there's going to be a dowel, and they can't move the seats in any way. They can sit there and close the door, they can open the door, but that's the extent of it. I'm going to opt against videotaping it. I'll revisit it if someone makes an impassioned and persuasive request for it. It sounds like while we might be here Monday morning going through some of the rebuttal witnesses, Mr. Gardner and someone from the state side could be down there in the sheriff's side after 10 o'clock saying, yep, this looks like everything is in the right place. Then they could observe this cut that the state's other expert made so that I could make a comment to the jurors in advance. They heard testimony about it already. You're also going to see this second defect, assuming it doesn't affect the dowel. It's going to be a big problem if it affects the dowel, but if it doesn't, I'll be able to say, you see this one other defect, You've heard testimony about how that got there. It has nothing to do with what happened on the night of the 25th or whatever language you guys want me to use. Otherwise, I think we're in agreement on things. Of course, the court reporter needs to be there. Mr. McIver needs to be there. All the lawyers need to be there. I'll be there. I'm not warming to the notion that they get in for a while with no dowel, and then we put the dowel in, and then they get in with the dowel. I think there's either a dowel or there's not. It sure seems like it would benefit the jurors to have the dowel there, as long as it doesn't stick so far back that they can't sit in the seat. And clearly, someone, Mr. Knox, Mr. Samuel, they were able to get in, and they were not impaled by the dowel. So if we can't, I hope you weren't. It seems to me that the dowel ought to be in there, and it sounds like the two sides could agree. Mr. Gardner's testimony was very refreshing. 2.5, 0.5, it's going to be effectively the same thing. Really the question would be, has something changed about the condition of the car that either you can't get the dowel through, or because of this other cut, it now goes from left to right or something, then we're not doing the dowel. But if it is essentially the same as it appeared in Knox photos and Gardner photos and Troutgate photos, then it ought to be in there. Now that you brought up the media, I will allow the media to be down there in a non-photographic mode. So we ought to make sure there's space for the media to be present, but they can have with them notepads, not cameras. And I guess the rest of those logistics are really up to you guys to sort out. I'm happy to do some blocking and tackling if we need it with the sheriff, but it sounds like his staff has been completely obliging.
Yeah, phone cameras too.
Yeah, no, there are no cameras down there. Keep talking. So, did that create issues or resolve issues?
That result.
Resolve, okay.
The result, we'll continue with, we'll work on it this weekend.
Okay, I think then the big variable would be, can we get the dowel in a way that satisfies both sides, variables, and then when do we do it? And I'm happy to be flexible. If it turns out, because of things that the sheriff needs to do, that it's 11 or bust, then we just stop whatever we're doing with witness X at 11 and say, guess what, field trip. And we get the jurors down there. One thing we didn't talk about is how, I'll tell the jurors they can't talk to each other while they're down there. I don't think we need to bring down one juror at a time. They can't all fit in the elevator at once, but I think we get all the jurors down there, and then we'll just have them go in numerical order. And I'll say juror 5, and if juror 5 wants to do anything with the vehicle, juror 5 can do that. And when juror 5 is done, then we'll do the next one. So all 15 have done it. And it may be that once they're done, Deputy Murphy or colleague might escort 5 or 6 of them back up to the jury room. Fewer people is always simpler. And I'll defer to Deputy Murphy as to, he may say, I'm going to bring down 8, and I'm going to bring down 7. And that really shouldn't affect us. It's just, I don't think we should do one at a time because we'll be building in an extra 10 minutes for each of the jurors. But those kinds of things we can amend on the morning of if we need to. Okay, so to recap, it'll happen. I'm going to get a report back from both sides as to whether they can agree on a positioning of the dowel. Jurors will be permitted, they don't have to, but they'll be permitted to get into the vehicle, close the door, and operate the vehicle. So as to your navigation system, we're not turning the car on, and someone through visual examination can figure something out, they figured it out. But that's not the focus of the jury review. We'll make sure there's room down there for everyone, meaning Mr. McIver and his team, the state's team. I'll let you know up front, if it gets crowded, we're not going to need 5 prosecutors. We'll bring it down to 3 because there are 3 defense attorneys. And if it gets real crowded, then like Survivor will lose one from blue team, one from red team, and we'll go. Mr. Rucker on the jury view? No, right now. Mr. Harvey?
No, sir.
Okay. State, how much time would you like before we regroup to talk about to have our charge conference?
Maybe about 10, 15?
Okay.
You know, what do you think?
All right. I knew you would say that. But no, he lives for these things.
You asked me first, I would have said 10.
Some of us have been working today. About 10. How about 10?
I'm fine with that. I'll come back out here around 3:40. Okay. All right?
All right, thank you.